Can you tell me what happened? We had a fight. He pulled me out of the window. He used a stick on me.
Well, he used a stick, and you used a gun.
Yes, I had a gun.
Well, how many shots did you fire?
Two shots to fire.
You do realize that the second shot killed him, right?
The second shot killed him. Yes, I do.
What are we going to do?
I don't know. On 7th June 2002, around 4:30 p.m. at Jalan Ma'ruf Bangsa in Brickfields, Kuala Lumpur, a murder occurred where the victim was Gobala Krishnan and lelaki Raja Mengundang and had Dato Balwant Singh accused. On that day, Balwant had left his office for home in his car, which was driven by his daughter-in-law, at around 4:30 p.m. Along the way, a near miss occurred when another car drove up close to him and prompted her daughter-in-law to honk at the driver, who nonchalantly sped off. However, a 33-year-old dispatch clerk who was riding a motorcycle several meters away did not take the blare of the horn lightly. Mistaking it as being directed at him, he pursued the car, shouting profanities at them, and every time they came to a halt in heavy traffic. The rider trailed them, continued the pursuit, challenging Balwant and his daughter-in-law to a fight, although they repeatedly tried to pacify the man by explaining that they had no intention of sounding the horn at him. At a road junction later, the woman pulled over and a confrontation between Balwant and Gobala ensued. Balwant claimed that Gobala had picked up a long piece of wood and used it to threaten and attack him. On seeing this, the lawyer, who was licensed to carry a firearm, warned Gobala that he was carrying a handgun and flashed it with hope that it would deter the situation. Unperturbed by the sight of the handgun, Gobala continued his violent tirade and even challenged Balwant to shoot at him. When dispatcher remained defiant and purportedly swung the stick at Balwant, the latter shot his handgun at him with a first warning shot and a second shot. The second shot being right at his right shoulder and stunned Gobala, hence he bled to death on the sidewalk and died. Dispatcher was riding a stolen motorcycle at the time, had a history of involvement with secret societies, and had spent time in secret residence prior to the incident. 2 months later, Balwant was charged with murder but was allowed bail by the court. In July the following year, he was acquitted by the court and deemed that he has acted in self-defense. So, with the facts of the case already being laid down, let's discuss on the issues that are relative to the particular manner of how this case was judged by the court. The first issue being whether the situation between the parties suggested that it was reasonable for the use of violence by Dato Balwant Singh. Second issue being whether the level of violence is proportionate between Gobala Krishnan and Dato Balwant Singh. So with that being established, we will be moving on now to the analysis of how this case was decided in court and how do we view it as a personal opinion. So let's move on to that. The first issue of the case here would be in establishing self-defense. Whether the situation between the parties suggested that it was reasonable for the use of violence by Dato Balwant Singh. In this case, the way they established the question of reasonableness is through eyewitness accounts. Balwant brought 12 eyewitness accounts to the trial, whereas the court examined the situations that were put on relative in justifying the reasonableness of the action between Gobala and Balwant. Among the issues brought at hand to justify reasonableness will be looked into as follows. The first issue was whether Balwant was pulled out of the car first. Balwant said that the deceased opened the car door and dragged him out forcefully by catching hold of the collar of his shirt. It was not put to the accused, which was Balwant, by the prosecution that he was not pulled out from the car. Instead, the cross-examination proceeded on the basis that he was pulled out. On the defense side of witnesses, and the cross-examination done by court did not manage to prove otherwise. Hence, it was therefore found that the accused was pulled out of the car by the deceased. This showcases that the action to step out of the car for the confrontation was not voluntary.
the action was actually forced as Balwant was pulled out of his car by Gobala.
So the second issue inside proving the first legal issue was, when did Balwant decided to pull out his gun? Balwant said in his testimony that he showed the deceased his pistol tucked at his waist, as the deceased, who was Gobala, continued to attack him using the stick. Gobala tried to strike him using a stick, landing on his upper arm. The accused said he was afraid of his life, and he took out his gun and fired a warning shot. There was absolutely no cross-examination by the defense of the accused as to the moment he pulled out his gun. Therefore, his evidence on this subject must be acknowledged with no backlash whatsoever. The lack of evidence and eyewitness account on this matter led to the belief that Balwant was indeed fearing for his life. The issue of whether Gobala was using the stick first as a mean of aggression and also being more aggressive and provocative even after Balwant showed his gun could not be proven against by the defense due to the lack of evidence and eyewitness account. Hence, the testimony for Balwant was again accepted unchallenged. A case that was referred and that can be referred to here is Beckford vs. the Queen. In this case, a police officer was the appellant. He was given a shotgun and ammunition and was sent to a house with a number of other armed police officers. A person named Heather Barnes had received a report, according to the appellant, that her brother had been terrorizing her mother with a pistol. Heather denied that the police had made a phone call and that her brother had been armed. The appellant said he saw a man running from the back door when he entered the house with an object that seemed to be a weapon. As he was being pursued by the police, the appellant claimed that Barnes had fired at the police, and the police fired back and shot and killed Barnes in the response. Currently, at that time, no gun was found at all. So the trial judge directed at the jury with this particular quote, quoting the judge, "A man who is attacked in circumstances where he reasonably believes his life to be in danger or that is in danger of serious bodily injury may use such force as on reasonable grounds he thinks is necessary in order to resist the attack. And if in using such force he kills an assailant, he is not guilty of any crime even if the killing is intentional." It was held that an appeal was approved and the conviction was totally annulled. The test to be applied for self-defense is that the circumstances that he genuinely believes them to be in the defense of himself or another person, a person should use force as defense, and that is considered fair. The similar principle is applied in this particular case of Balwant vs. Gobala Krishnan. Balwant is the public prosecutor, where it does not require Balwant to be inflicted with serious injury before the exercise of the right of private defense can begin, due to the fact that a person is not bound to modulate his defense step by step before the right to defend himself can begin. Hence, it was agreeable to say that it was reasonable for Balwant to resort using violence. Hence, that is the first legal issue put aside, where we can determine that it was indeed reasonable for Dato Balwant Singh to use violence in self-defense. So with the first legal issue put aside, let's move on to the second legal issue at hand, in the elements of self-defense. That issue is whether the level of violence is proportionate between Gobala Krishnan and Dato Balwant Singh. Again, the court relied on eyewitness accounts to establish whether the level of violence was proportionate between both parties. There were also several issues discussed in order to determine the conclusion. So let's discuss the issues as follows in this particular manner. So the first issue would be the manner in which the deceased, which was Gobala, used the stick before the two shots were fired. It was stated in discussion of the court where when the stick moved towards his face, he warded off the stick. It was already established by the accused, which was Balwant Singh, and the witnesses that the stick landed on his upper arm. Gobala poked Balwant with the stick and kept aiming at his face. Gobala then jabbed Balwant's chest with the stick, according to eyewitness accounts. When Balwant showed the gun to Gobala, he swung the stick at him again. It landed on his upper arm again. After the first shot was fired, Gobala launched the stick forcefully at the accused's chest. Balwant said that as a result of the assault, he was injured in his arm and chest. It was observed that the prosecution version of the use of the stick did not touch Gobala. Was stated that it did not touch Balwant, and that prior to the second shot, Gobala was holding the stick down and was not placed on Balwant. Neither was it suggested to him that the injuries he had sustained were not caused by Gobala, and said that the two injuries on Balwant are consistent with his complaint of having been assaulted with a wooden stick. It was simply a consistent story. Hence, it was deemed that the injury sustained by Balwant was in fact caused by the contact of the stick by Gobala. The eyewitnesses on the defense side were inconsistent with their story. Hence, Balwant's testimony was accepted due to the consistency with the evidence provided. So the second issue in this legal issue is whether both of the weapons could be constituted as deadly. The debate here is whether the weapons used by both parties were considered deadly. For Balwant, it is quite obvious that a gun is a deadly weapon in itself and can be triggered and be deadly from a long range. For Gobala, the stick that he used was examined by the court. With the proven nature of how he used the stick previously and how it caused injuries to Balwant, the court examined the nature of the stick being used. However, the stick was not an ordinary stick. According to the eyewitness accounts on the side of Balwant Singh, it was a thick branch and more than 4 feet in length, hence it was carryable by a person. It was big enough to cause a person's skull or bones to crack if hit with. Balwant said in this cross-examination that it is a dangerous weapon, while it is said that it could cause grievous hurt and possible death if it was placed to the head. It would thus be described as a weapon of offense. The law that was discussed earlier shows that it makes no difference that Gobala was armed with a stick and the accused with a gun, which was Balwant Singh again, and that serious injuries need not to be inflicted before the right of private defense can begin. So knowing the possibility of what could have happened, adding to the unintentional act of shooting Gobala until he died on the pavement afterwards, Balwant was deemed to have acted reasonably, suggested by another major aspect of the case, which that he has justified his burden of proving, as he is an accused counsel, that allowed the probabilities to be weighed in by the court to come to such a decision. So a case that is similar, where the burden of proof lies on the accused, is the case of Public Prosecutor versus Teo N. Cheng and Ors. The appellant appeared against sentence on the grounds that there had been no violent assault, no weapon used, no threats, and the relationship between the appellant and the complainant prior to the offence had been pleasant. This was of course a rape case between both the appellant and the complainant. So, moving forward from that case, the court held that dismissing the appeals against conviction and sentence with a plain reading of a section in the Evidence Act, which showed that the complaint to her sister over the phone and to her mother were admissible as corroboration of the complainant's own evidence. This evidence not only confirmed the material particulars in the complainant had been raped, but also that the appellant had raped her. The appellant who was accused had failed to satisfy his burden of proving, hence was convicted. Similarly, in this case, every detail and probabilities that was stated by Balwant and was deemed by the court were all backed up with sufficient evidence and eyewitness account, where the nature of how Gobala used the stick would have more likely created a deadly scenario that was supported. Hence, the act of violence was deemed proportionate between both parties by the court. The rule of law of the right of private defense was applied at the end due to the fact that it was deemed proportionate. No debate after that, with the lack of evidence on the defense side that could not prove anything in the case of Gobala Krishnan. So, taking into account with all the discussion we've made previously, it shows that it makes absolutely no difference that Gobala was armed with a stick and Balwant was armed with a gun. It is not necessary to cause serious injuries before the right to private defense can begin. It is also not necessary for the injuries already inflicted, but it is necessary that the injury that could be inflicted should be recognized in court, the things that could have happened if the right is not exercised. In the face of the danger he encountered, there is no responsibility on Balwant to run away. In the face of risk, Balwant will turn around and strike. In private defense, a gun can be used and the right extended even to the killing of the aggressor. It would therefore be argued that on a balance of probability, like we discussed before, Balwant proved that he had behaved in the exercise of the right of private defense. Therefore, Balwant did not commit an offense, hence he was subsequently acquitted and discharged. So, with all of that being said, here is my personal opinion on the particular case. So in my opinion, based on the available evidence and accounts from a legal standpoint, I would have to agree with the decision of the court that Balwant should have been acquitted and not charged with any offense according to the right of self-defense. Gobala Krishnan had all the odds against him due to the lack of competent witnesses on his side, where the corroboration of evidence led the court to believe that it was insufficient. Legally speaking, when that happens, Balwant's testimony of any sort will be accepted due to him still being alive, and the larger amount of evidence that helped the case in his favor. Well, I would say that the case that Gobala Krishnan would have is to gone by attacking whether the violence between the parties was proportionate with each other. Knowingly that Gobala had previously participated in secret societies and practiced illegal acts in the past, it would be very hard for anyone to willingly provide eyewitness account that would be good enough for Gobala. But I would agree only to that extent it would be sufficient due to the fact that it was something that I believe that he started first. The fact that he went on a pursuit and performed aggression first was already an indication that he had a lot of influence in the confrontation. He was playing a pivotal role in the confrontation. It was also proven by court that the shooting was unintentional and it was directed at a body part that would suggest that if the shot would be at other body parts which was vital, then the question of deliberation would have been questioned with the intention that he was actually trying to kill him. But that was not the case. Balwant also had a daughter in his reach, but he also might have feared any action towards the daughter. Understanding the size of the stick used, I would have to agree that the weapon would be deadly if a blow to a head. If you want to say differently for a gun, I would disagree, because guns are also deadly in certain parts, but I would agree it is more deadly in a lot of parts, honestly. But I would agree with the decision of the court. Self-defense is sufficient enough. Although I have disagreements with how a person counterreacts to an act that caused death, I personally agree that is not proportionate in terms of violence due to the fact that it constitutes death, but knowingly that the court has showcased that it matters that the probability stacked against a person also can be used. For instance, if the person had shown, in this case, no lack of no slowing down in terms of aggression, he would have gone forward and do some more terrible things due to the fact that if you see a man with a gun and you're holding a stick, I would think that he would have reacted in also trying to kill him. So I think that I would have to agree with the decision of the court, and I think that the case has been rested. With that, Assalamualaikum warahmatullahi wabarakatuh, and thank you for listening.